Okay, we are at plus 200 attendees right now, so we are going to go ahead and get things started. I'm sure there'll be some more people to sign on, and we will record this session just in case you have to leave early or if you want to share it with anybody else. For those of you who may not be familiar, the NPDA supports franchise and independent power sports dealers through education, advocacy, programs, and practical resources, all focused on helping dealers build a stronger, more professional, and more profitable industry. This partner webinar series gives dealers direct access to the companies, tools, and people helping shape the powersports retail landscape with one goal in mind, keeping dealers informed, connected, and exposed to ideas they can actually put to work. Questions relating to recent FTC actions have been one of our most frequent inquiries, so we are proud to have one of the NPDA's original partners speak on this topic. Leonard Bellavia is the founding partner of the law firm Bellavia Cohan, aka DealerLaw.com, which is a national firm representing dealers in the powersports, automotive, and marine industries. Len has been involved with the NPDA from the very beginning, as his firm filed the legal documents to form the association back in 2021. He has represented powersports dealers nationwide for many decades and has extensive experience in regulatory and enforcement matters regarding dealer advertising on both the federal and state levels. NPDA is pleased to welcome Len back to discuss the recent Federal Trade Commission actions that directly impact our industry and the day-to-day operations of our dealer members. If you have any questions, please look for the Q&A button in your Zoom toolbar and just post any questions you have down there. At the end of this presentation, I will take some time to summarize and present those questions to Mr. Bellavia so that we can get you answers to those. Any that we don't get to, I will feed to Mr. Bellavia's team after this presentation, and we will work on getting those posted onto the NPDA website once we have those answers for you. Thank you. And with that, I'll turn it over to Mr. Bellavia.
Mark, thank you very much. Thank you for having me present this important conference. This is a subject matter that has become very, very topical. And all of the motor vehicle industries are out front and center trying to educate dealers and advertising colleagues and third-party platforms to come into terms in enforcement of the FTC guidelines. So what I'm going to try and do today is take a pragmatic approach so that by the time this webinar ends, every dealer or manager who's in attendance will have an action plan, because I find that sometimes when we talk about different provisions of the law, it can become theoretical or too esoteric, and then the webinar ends and then people say, what do I do now? So what I've tried to do is kind of weave together the substance of the law, try and put in non-legalese, plain English, what the Federal Trade Commission is dealing with, why they're dealing with it, what the practical implications are to dealers, and an action plan. And you'll see towards the end, because I think a lot of this will crystallize when we talk about specific advertisements, the way that dealers present their products and services to the general public. So we'll have some samples of different ads, and we'll try and be a little bit interactive, even though we're not live and in person. We're going to attempt to do a poll with respect to certain types of advertising that everyone on this call is familiar with. So we'll run the gamut. We'll try. Obviously, I'm going to have to go through the different provisions that the Federal Trade Commission is dealing with. We'll go into a little bit of history about how we got here and why this is what I consider to be a turning point in the motor vehicle retail industry. I'll even give you some context of how some of these compliance efforts have come to fruition over the years, so you can put this in proper perspective. So that having been said, I think what we'll do is let me first identify the provisions of the Federal Trade Commission that we're dealing with, because I find that when you talk about provisions of the law in the abstract, even though I can convey to you, what the essence and what the language of the provisions say, unless you see it, it becomes a little bit more difficult to articulate it. So with that, let's see if I can, without getting too deep in the weeds here, I wanted to just kind of demonstrate to you that although this sounds very lofty, it's really very simple. I highlighted in yellow, this is the actual Section 5 of the Federal Trade Commission Act that everyone is talking about. And as you can see, it boils down to really just two provisions. And it's rather plain. I know you can't really see it, so if you just bear with me, I'm going to read from those two sections that are highlighted in yellow so that you have a sense of what this is all about. And everything that we talk about today is going to revert back to these provisions. So the first highlighted section says unfair acts or practices. And you'll see 3 bullet points there. An act or practice is unfair where it causes or is likely to cause substantial injury to consumers. The next bullet point says cannot be reasonably avoided by consumers. And the third point says is not outweighed by countervailing benefits to consumers or to competition. So before I go to the deceptive acts section, just understand what I just read to you is about as generic and broad as anyone could ever articulate about what type of acts are considered unfair. And it's not just power sports, it's automotive, it's marine, and it goes way beyond these industries that we're most familiar with. This is being implemented against hotel chains. For example, when you book a hotel room and it says $259 a night, and you get to the hotel and you find out it's $325 because of a resort fee or other charges imposed by the hotel. Well, the Federal Trade Commission is going after those practices using this same language. So this is about as broad as you can possibly imagine. I know they're going after ticket brokers because oftentimes on Ticketmaster or other platforms, you wind up buying tickets and find out that the price that you thought you were paying is much less than what you're actually paying. Airbnb, housing, that's also under scrutiny, and they're utilizing the same language. So this was not devised and enacted specifically with motor vehicle dealers in mind. And I'm going to demonstrate as well the deceptive acts. So unfair acts and deceptive acts, they all essentially arrive in the same place, but just so you can see what those bullet points say, deceptive acts or practices is defined as an act or practice, defined as deceptive, where a representation, omission, or practice misleads or is likely to mislead the consumer. A consumer's interpretation of the representation, omission, or practice is considered reasonable under the circumstances. So that's what we call the reasonable consumer standard. And then finally, the misleading representation, omission, or practice is material or meaningful. So with all this talk about the Federal Trade Commission Section 5, I just read to you what the entire law says. So it's broad and it's general, and it can apply to anything and everything. So it gives the FTC wide ability to look at a particular advertisement and determine whether it fits under the definition of unfair or deceptive. So having said that, I think maybe a little history might be appropriate. So the question becomes naturally, why now? Why is the Federal Trade Commission suddenly focusing on an act that is about 125 years old? This was not just enacted. This has been with us longer than all of us on this call. So why now? And I think the answer is because this is something that appeals to both, all political parties. Just to give you some history, when you go back to the Biden administration, the Federal Trade Commission was endeavoring to enact something called the CARS rule. It was really designed around the automotive industry, but the idea was basically to create new legislation that arrived at the same place. It was all about unfair and deceptive practices where dealers were not being considered to be transparent. And there was exemptions for the motorsports industry and the marine industry. They were really targeting the automotive retail industry. However, that effort never really resulted in any provisions of the act being enacted or promulgated because of some procedural missteps by the Federal Trade Commission, which are really not relevant here. The point is, this was initiated about 2 or 3 years ago, and it never got to see the light of day because the FTC didn't properly go through the channels, and the Sixth Circuit Court of Appeals decided that it should be vacated altogether. So fast forward to 2026, and now you have the Federal Trade Commission saying, well, we really don't need to promulgate new laws. We have this 125-year-old Section 5, and it does the same job, but we need to invoke without going through the legislative process because it gets very political. So why recreate something that doesn't need with the Federal Trade Commission's Section 5 has enough teeth. And this is why this is what I consider to be a watershed moment, because the last time something like this was undertaken was back, let's go to this page, the Monroney label. I'm sure many of you, even though that's a term that you hear in the automotive space, every car in a showroom has a Monroney label. That had its origins back in 1958. So we're talking about 68 years ago. And the reason I highlighted a little bit about the history of the Monroney label is because when you look at the highlighted provisions, because this is what the purpose of the Monroney label back then, 68 years ago, was designed to protect consumers from inflated list prices, undisclosed fees, and unnecessary add-ons. It's essentially the same thing I just read to you about Section 5. So here we are 68 years later, and I'm referring to Section 5 as a reboot of what was intended by the Monroney label. So it's recognition, it's somewhat, rebooted because of online shopping and some of the nuances relating to the current day retail environment. And most importantly, Section 5 has very strong enforcement authority with substantial fines. And that's why this is really what I consider to be of major significance to every retailer in the retail, automotive, and marine and power sports industries, because the fines are astronomical. They're over $50,000 for every potentially, and I'll explain how those fines are implemented. But potentially, if a dealer decides that they're going to thumb their nose at Section 5, it wouldn't take much to put a dealer out of business based on the amount of money that could be at stake here. So let's get back to where we were about a month or two ago. Back in March, the Federal Trade Commission said enough is enough. Consumers are not being treated right. They were inundated over several years, many years, with consumer complaints outlining problems they had with buying goods and commodities, not just automobiles and boats and motorsports, but everything. However, most of the complaints came relating to purchases of cars, commodities like boats and motorsports. So warning letters were issued to 97 automobile dealership groups. So why is that important? Well, what the Federal Trade Commission did was canvassed the advertisements of dealers all over the country. Now, we're just talking for the moment about automobile dealers, and they came up with 97 letters, not just rooftops, but 97 dealer groups. Now, they have not disclosed the names of the dealers. It's really not relevant, really. So what we're looking at now is a generic warning letter with the names of the addressees deleted. However, the substance of the letter, and we're going to get into these some points, 2 on the first page and 4 on the second page, which we'll get into. But essentially, they summarize the categories of violations that they feel are most commonplace in the retail motor vehicle industry. So it's important, although, quite honestly, this webinar would take about 5 minutes if all we did was go over these 6 bullet points, because each one of these bullet points are very familiar with anyone who sells boats and cars and power sports. Not because you've engaged in these practices necessarily, but it's rather common. You'll recognize it even if you ever bought a car as a motor vehicle dealer and some other specialty. So if you're a motorcycle dealer, you must be driving a car. So you probably went into a showroom and said, "Hey, look, I'm familiar with what's going on here, but it's still unfair." And I represent dealers. I've represented dealers for almost 40 years. I've been in front of the FTC and state attorneys general, and Consumer Affairs and Department of Motor Vehicles. So I'm usually on the side of defending dealer practices. In fact, I'm always on that side. However, every so often, I'll get a call from a friend or a niece or a nephew who said, "Hey, can you help me buy a car?" And I'll kind of be like the maven or the third base coach, and I'll get shocked. I suddenly, sympathize with the consumer because this is my own family or friends. And I'll say, "That's not fair. That's a violation of law." Of course, I say that privately because sometimes these are my own clients. And I say, one day the government is going to do something about this, because it's really not fair to the honest dealer. The problem is dealers get pulled in to this web of lack of transparency because it's almost to the point where if you don't emulate what a competitor is doing, you'll sell a lot less cars, you'll be a lot less profitable, and it puts your dealership at risk. So I think we're at a point where most dealers that believe in honesty and integrity are aligned. Of course, this is something we have to pay attention to, and we shouldn't be fear merchants. When you listen to some webinars, and many of you may have listened to or watched the webinar with the FTC and the NADA about a month ago, it was actually very helpful, but it's also a little frightening. So, and I don't think the FTC was intending to be fear merchants. However, they necessarily had to go through all of these different things that were problematic. And if I were a dealer, I'd say, geez, do I want to even go into work today? Because it seems like I have a bullseye on my forehead. Every little thing potentially could result in a $50,000 fine. And if I'm doing it in one ad, it's probably applicable to everything I'm advertising because I'm using a third-party vendor that has uniformity in the way they're advertising my goods and services. So if I'm guilty with one ad, I'm probably guilty with 100 ads, and multiply that times $50,000. It doesn't take long for your dealership to be at risk. So I think the underlying message from this presentation and every other presentation that's being given out there in the various industries, not just motor vehicle, but hotels and all of the other things, Airbnbs, this is a moment in time, much like the Monroney label back in 1958, where dealers have to take a pause and reinvent their businesses because the federal government is really not fooling around. And how do we know that? Because this is bipartisan. This is the CARS Act was attempted to be enacted during the Biden administration. And essentially the same enforcement is being initiated through the Trump administration. So this is not something that will go away in 2 or 3 years. I think essentially the judiciary, the regulatory agencies are all in sync. And quite honestly, the retailers are in sync that the industry needs to be cleaned up. It needs to be cleaned up because if it is, it makes your dealerships stronger so that you can actually do things in an honest way. And I'm going to go into different examples of why this spills over into some of the other things that you deal with that doesn't necessarily relate to pricing. So before I get ahead of myself, I think it's worthwhile let me just go through the 6 things that the FTC is most concerned about. Like I said, this will not take a lot of explanation because you're going to recognize each one rather easily. Here's number 1, just to give you an example. Hidden fee advertising. And when you read this, consider doc fees. Consider whatever you want to call them, dealer processing fees, doc fees. But that number 1 here is hidden fee advertising. And just think of the situation where a customer comes in, likes what you have to sell, agrees on the price, $15,995. You start writing up the order and you add a $900 doc fee. Consumers are upset about it. They didn't know about it in advance. There's a unique problem in the powersports industry insofar as destination fees and setup fees. Setup fees are sometimes, at least in the automotive space, called PDI, pre-delivery inspection, but it's essentially the same task where there are costs being borne by powersports dealers that are not even reflected in the MSRP of the manufacturer. So that kind of puts the motorsports dealer even in a worse position than an auto dealer because at least the MSRP, the Monroney label, reflects destination and setup fees. You don't have the same ability. So oftentimes, I'm preaching to the choir. However, in the motorsports space, oftentimes the MSRP is less than the amount that you're actually going to sell the vehicle for because you have to recoup the setup fees and the transportation fees. So the hidden fee, this number 1 becomes more relevant in the powersports industry, I find, than it does in the automotive space. So essentially what this says is, and the underlying theme of the FTC here is that there has to be price transparency. The price you advertise must be the out-of-door price. So the need to incorporate your dealer fee or your processing fee no longer exists. We can talk about later why you can still mention it, but the point is the prominent price has to be the out-of-door price, and we'll illustrate that a little bit later on. So the hidden fee advertising, I mean, it's not just about the dock fee, but that's essentially what is troubling the FTC. These dock fees are not in the advertised price, and now they must be in the advertised price. So there's going to get to a point here when this is fully implemented. You may reach this point. It might not be in the first month. It might not be in the sixth month. You might, and I'll explain why. You might want to wean off of the dock fee because it's irrelevant, because the price that you're going to have to advertise is the out-of-door price, except for taxes and motor vehicle registration fees. We call them mandatory fees, which you don't control. So the price you advertise must include everything. We'll get into some other nuances in the next slide. Must include everything except state sales taxes and motor vehicle fees. Okay. The number two, unavailable rebate advertising. This is advertising a price that reflects rebates or discounts not available to all consumers. We all know what that means. It means that if there are certain rebate, you see this more in automotive because you get first-time buyer, college grads. The pricing of motorsports doesn't lend itself to all these different levels of rebates, but there's still rebates nonetheless that don't apply to all consumers. So the takeaway from the second bullet point that the FTC is focusing on is that whatever you advertise, it has to include rebates and discounts that are available to all consumers. It doesn't mean you can't mention rebates that would only apply to certain consumers, such as loyalty rebates or conquest rebates, but they have to be disclosed below the line. So the prominent price in your advertising, whether it's on your website, whether it's in social media, whether it's on radio or television, or email blasts, direct mail pieces, everything you can think of, including verbal conversations over the phone. The price that you give to a consumer must include everything, and any rebates that are reflected must be below the line, and it must be clearly disclosed so that the price that you advertise, to the extent it contains rebates or discounts, they must be available to all consumers. We'll give you some examples later on. Okay, concealed down payment or trade-in. So this is a little more egregious. Again, you might see this more in the automotive industry. However, oftentimes you'll see ads for products that say $19,995, and then the customer comes in and you show them the fine print that says this assumes you have a trade-in worth $3,000. Or it assumes that there's a $2,000 down payment. I don't know that there's any really good faith defense to that type of advertising, but clearly and understandably, the FTC is zeroing in on that. I remember years ago, and I'm sure many of you do, ads that say, whatever trade-in you have, we'll give you $3,000. And then, of course, depending on what it's really worth, if it's worth less than $3,000, the dealer makes up for it by jacking up the price on the retail side. So again, it's not transparent. These are the things that are now historical. They're things of the past. Don't even go there anymore because this is a real sweet spot for the FTC and the regulators there. They are, the director is an automotive experienced individual. He actually came out of the automotive industry, so he knows everything about retailing boats and cars and motorsports. So you're not going to trick anybody. So err on the side of being ultra conservative. Again, we'll get to that in a minute because I'll give you a lot of examples of the things to avoid. But anyway, this is really in their sweet spot of things that they're focusing on. Dealer financing. All right. We've all seen this, and this is commonplace in all of the motor vehicle retail settings where financing is the price is conditioned upon using dealer financing. That is now something of the past. That you still can do it. However, that could reduce the price, but the price you advertise cannot assume that the consumer knows that he only qualifies for that advertised price if he uses dealer financing. So I'll give you some examples of that later on, but just so we're clear on this, the price you advertise has to be the prominent price. That's called the out of the door price. and it cannot be conditioned upon using dealer financing. So if you have a price of $20,000, that's the price, even if the consumer doesn't finance with you. That's the price if the consumer pays cash. You can discount it. You can still discount it when the customer comes in, and you can say to the customer, look, if you finance through us, that 20,000 will be reduced by $1,000 or whatever the case. But the point is, the FTC doesn't want dealers luring in customers under the false pretext or misunderstanding based upon language that's not entirely transparent, so that the consumer gets disappointed. And then we all know the process. Consumers sometimes capitulate because they're short on time, or they already spent 2 hours at your dealership, or they realize they don't want to start from scratch and go to another dealer. All of the things that some of the less scrupulous dealers rely upon to increase sales activity. The federal government now is wise to that, and it needs to be eradicated from your playbook. All right, next category, requiring consumers to buy additional items not reflected in the advertised price. That's preloading products. Again, I know this happens to some extent in the power sports industry. It's more common in the automotive. I don't know about the marine industry, but we've all gone into dealership showrooms and seen addendum stickers that say this car already has rust proofing and extended warranty protection, wheel protection. And the idea is the salesperson will say, well, look, all of these things add up to $4,000, but this is a package you're only getting for $3,000. It's already on the vehicle. And even though the price on our advertisement said it was $35,000, the car is $39,000. That is absolutely taboo from now on. It doesn't mean you cannot offer these packages. It just means they have to be discussed below the line. So the advertised price must exclude these items. And then if you offer it to a consumer, there are disclosures that are needed to make sure the consumer doesn't feel that he or she is compelled to buy these additional items. So there has to be prominent disclosure that these are voluntary, optional, additional add-on items. So pre-packing, payment packing, preloading is now something of the past, and the FTC is vigorously looking for dealers who continue to engage in this type of a practice. All right, this one is a little easier to understand, but I can tell you that this goes on every day, all the time, in all industries, all motor vehicle industries. And you see it most often with respect to both in-transit vehicles and sold vehicles. And I know, and I've tested this out. I've gone on client websites in preparation for these presentations in particular, and I find that, and you see this, by the way, in real estate a lot. This is even more abused in real estate, when real estate brokers don't take sold homes off their websites because they want to get buyers. They want to find out that there are buyers out there, and then of course they'll try and switch them to a different house. So a home that is less expensive, that presents very well, somehow stays on the realtor's website for months after the house is sold. Similarly, in the automotive and the marine and the power sports space, the FTC wants to know that once you deliver a bike or a jet ski or whatever the case may be, that it comes off your website within a reasonable time. What's a reasonable time? They haven't answered that specifically, but I can tell you it's probably going to have to be a matter of days, no more than a couple of days. The best practices every day at midnight, you purify your inventory. I don't know that they'll hold you to midnight the same day, but certainly if it's still there 2 or 3 days later and a consumer feels abused by having come in thinking the vehicle is still on your premises and it's not, and they complain to the FTC, well, you might get a knock on the door, and that's a $53,000 violation. Let's talk about in transit. Vehicles that or units that are coming into your inventory, you probably know that a long time before it actually shows up. In the automotive space, you order a vehicle, it could take 3 months before it comes in. So a dealer who puts an incoming F-150 pickup truck as in transit is violating the FTC Section 5 rule, because that's not imminent enough. They want to know, the FTC wants to know that if you're going to describe a vehicle or whether it's a motorcycle or any product that's in transit. It means it's expected in your inventory in a matter of days, not weeks, and certainly not months. So you have to be vigilant because that's considered unscrupulous and non-transparent with the consumer. They don't want consumers being uh, lured into your showroom under a false promise that a vehicle is either in your possession or will be there in a day or two. So this is something they'll be focusing on. So I just went through the six prohibitions. As you can see, I could have just made this whole webinar about those six and we'd be done with it, and you understand them all. It's pretty obvious. However, I think some color is needed so that you can redesign your business in a way that protects you, but at the same time doesn't limit your ability to be profitable. And I'll tell you that I've noticed already that there are vendors out there, consultants that are trying to figure out ways to help dealers remain profitable, even though they might not have the same liberties that they could take with respect to vehicle price advertising. So I guess the question is your dealership singular in that its only value proposition is pricing? So what we're seeing now is advisors, I don't mean lawyers, but marketing people saying, listen, it's time to expand your offering so that you're not one-dimensional. You've got to talk about other things in your marketing. And I want to be careful to stay in my lane here because I'm a lawyer. I'm not a dealer. I'm not a marketing person. But I think it goes hand in glove with trying to explain to dealers that it doesn't mean, I mean, the classic example is a dealer principal, a dealer owner after this webinar will say to their general manager, all right, we got to abide by these rules, but I don't want to lose a single sale and I don't want to lose a single dollar in gross profit. So now the manager, you created a conflict of interest, right? Because your manager wants to please you, wants to do the right job, doesn't want to expose you or him or herself to liability based on violating, but he also wants to make sure that you're performing the way you have performed in the past. So we'll go over a few things that, even though I'm not a marketing person, I can tell you that they're being talked about as ways to try and offset some of the potential, downsides of having to comply with all of these Section 5 regulations. So let's go through a couple of bullet points that I think are relevant. First of all, some of you, I'm sure, are saying, well, my state law requires, because there are 50 states with, many of them have different laws with respect to doc fees. Some states actually say that you cannot disclose a doc fee as part of the price. That's the other extreme. That's the opposite of what the Federal Trade Commission is saying to you. There are other states that, with respect to doc fees, say they're discretionary. Some states require them. Some states require that they be disclosed, not disclosed, or they're discretionary. Here's the takeaway on that point. There's something called the federal preemption doctrine. What that means in a nutshell is that where a federal law and a state law conflict with each other, the federal law trumps the state law. So that kind of makes this discussion easier because it almost doesn't matter what your state says about how you should disclose your doc fees. The point is the federal government, the FTC, says you can have doc fees, but they have to be in the prominent price, the drive out price of whatever it is you're selling. So some will argue, well, that's the death of the doc fee. What's the point of disclosing it if it has to be in the end price that you're advertising? And I can understand dealers saying, well, I get it. It doesn't really matter. If the out the door price is disclosed, it doesn't matter what it consists of, that's the price. But some consumers are kind of conditioned now because they've been paying doc fees for years and years and years. So I get it where a dealer says, well, I still want to mention the doc fee so the customer doesn't think that my $20,000 advertised price is pre-doc fee. Because then I'm actually hurting the consumer because the consumer who's bought a lot of motorcycles from me in the past knows I have a $900 doc fee. So they're going to assume my advertised price is not inclusive of the doc fee. So it's okay to say the sale price of this unit is $20,000, which includes our doc fee. So that might be a reason why you continue to use that term until customers are weaned off that maybe a year or two from now. Let me mention something about bullet point number 3, because I'm assuming that on this presentation, we have dealer owners and we have general managers and we have F&I managers and other fixed ops managers. This is an important takeaway. This is how serious the FTC is regarding Section 5. It is imposing personal liability. Now, when I say personal liability, your dealership probably runs as either a corporation or an LLC. So you have that corporate shield. Under Section 5, if the FTC finds that you're not transparent and you're violating, multiple bullet points that we just went over, these prohibitions, it could actually impose joint and several liability on the entity, yourself as the dealer owner, a manager, a salesperson. So that's a reason, that's a key reason why we can't play games with this new FTC rule, because you can't hide behind the corporate shield. Ultimately what happens in worst case scenario, if, there was a dealer that you may have heard about in Maryland that just got hit under the same Section 5 with a $75 million restitution order from the Federal Trade Commission and a $3 million fine. So $78 million. Now, it was a multi-roof dealership, who knows? Presumably they have the money to pay this. We don't know. But imagine if that liability was imposed on the dealer owner and the manager. So a bankruptcy filing by the company would not exculpate the owner or the manager from liability. So that could lead to personal bankruptcy on top of the dissolution of the company. So that's why this is really something that every retailer should pay attention to. The FTC means business. So I'm going to bounce around on some of these bullet points. The next one is FTC enforcement. Is it a blessing or a curse? It's a curse if you ignore it, because inevitably you'll be put out of business, because they're really focusing. And there's 18,000 motor vehicle dealers, new franchise motor vehicle dealers. There's almost the same amount of independent auto dealers. There are, I don't know how many thousands of marine dealers. I think there's like 3,000 marine dealers. You all will know how many Powersport dealers there are in the country. So you might say, well, there's too many of us for them to pick on me and find me. I wouldn't bank on that as a defensive strategy. They are really staffed to, and also there's AI now. They can review ads much faster than they have in decades past. So I wouldn't assume that you're going to get lost in the weeds here. So is it a blessing or a curse? It's a curse if you ignore it, because you will get undiscovered. And it's a blessing if all of your competitors have to follow the rules, because now you're playing on a level playing field and you can start talking about the other reasons to buy at your dealership. Consumers don't necessarily begrudge the notion that you have to make a profit to stay in business. So you don't always have to advertise price. There's nothing that prohibits you from advertising a price that's very, very competitive. That's up to each one of you. You don't have to advertise a price that puts you in the red. However, whatever price you advertise, you have to honor that price now. So, all right, so that's one bullet. We're going to get into some ways to overcome that. Let's go back up to the second bullet point. The practical consideration here is that compliance has to become a core department function. Just like you have a fixed ops department, you have a sales department, you have a used vehicle department, you have a bookkeeping department. Compliance now has to become as important as any one of those other departments. Compliance in the past has always been, well, I don't know the answer to this. Let's call our lawyer, and don't talk too long because we're going to have to pay him, by the hour. That approach to compliance must change. You're going to have to come to terms with compliance is going to become as important in your dealership as the sales department or the service department. And I'm going to give you some tips on how to get to that point. But ultimately, the dealer owner has to preside over the compliance department. I'm not saying you have to actually implement it on a vehicle or a unit by unit basis, but you have to quarterback it by having in place the systems so that you don't run afoul of things because it is very, very simple to run afoul of these things, even unwittingly. Example, salespeople have social media pages. It could be on Facebook advertising your products. You don't necessarily see that, but to the extent that that salesperson violates one of these 6 prohibitions, guess what? It goes upstream to the dealership. The FTC will hold your dealership responsible. It's almost impossible. It's almost impossible to be vigilant and be 100% compliant. And I think, again, not to be a fear merchant, because I think the sense that the professionals are getting is the FTC is not on a witch hunt. They're not trying to put 17,000 auto dealers or 5,000 power sport dealers out of business. They're trying to put consumers into a place where they can responsibly shop within a reasonable period of time and not be confused and confounded and victimized. So you don't have to worry about the FTC sitting at your front door every day trying to put you out of business. The only time I think you're going to see them is if you systematically engage in practices that they're asking you now. They're giving you a free peek. Now, that's what those 97 letters were all about. They knew full well that every dealer, marine, power sport, and motor vehicle automobile dealer, will learn about these 97 letters. So this is your window of opportunity. By the way, those 97 dealers have not been fined. Those letters were worded very carefully to say, we think you may have violated some of our prohibitions and you need to look into it. So these were not lawsuits. They were not injunctions. They were not fines. It was a shot over the bow of those 97 dealers who presumably were violating some of these rules. But the real reason I think the FTC did this en masse is so that it would get notoriety across all industries and dealers would get their house in order. So you kind of got this warning shot. However, this is not a free peek forever. So once this webinar is over, my hope is that you're going to sit down with your management team and figure out a way to come into compliance quickly, because this free peek is probably just 30 days long. Let's talk about, old days, the pay-to-play philosophy. This kind of dovetails into what I'm saying now. The pay-to-play philosophy always was, and this goes back to when I started defending dealers in front of the attorneys general back in the 80s and 90s. The dealers always said to me, all right, let's go in. We got cited, but I sold, an extra 100 cars a month for the past 5 years. So I have plenty of money. I squirreled enough money aside to pay this fine. And the fines then were not $50,000 per violation. They were maybe $1,000 per violation. So if a dealer had to pay $50,000 to pay the attorney general a fine after, probably benefiting by $3 or $4 million, it was a pay-to-play concept. They didn't really care because they already made enough money where they can offset a violation by just paying off and paying a fine that is small in comparison to the benefit they got. Here at 53,000, and that's going up in 2026 to 56,000 per violation, you could be put out of business in 10 minutes. So the pay-to-play philosophy is something of the past, doesn't exist anymore. Blue sky laws, what does that mean? Blue sky is a term of art that's utilized in retail motor vehicle dealerships. And those of you who have bought or sold a dealership understands what blue sky is. It's similar to goodwill value or intrinsic value of your business. It's an intangible. Sometimes it's a multiple. So if you're making $1 million a year and you decide to retire, you might say, well, my dealership, my blue sky value is worth $4 million because it's a 4 times multiple. So why is that relevant to a presentation on FTC Section 5? Maybe the best way to explain this is to give you an example. Let's say the dealer in the next town, who historically has been engaging in all these 6 bad practices and has made millions of dollars because unsuspecting customers have fallen victim, and he's benefited by engaging in these unseemly practices. And he suddenly comes to you, coincidentally, the same month that the FTC is enforcing Section 5, and he says, you know what, I think I want to sell my business. Would you buy it? Now, as an astute buyer, what's the blue sky value of that dealership? If you know that their practice consists almost entirely of violating each one of those 6 prohibitions. A, is he selling because he realizes the jig is up? And B, regardless, are you going to pay a multiple of 3 or 4 or 5 times his $1 million profit when you know that all of his customers are not happy or potentially not happy? Because we all know what happens. And I saw this after the COVID era when auto dealers in particular were charging list price and way over list price. They made a lot of money during that period of time. But guess what? There's a period now where they're giving it back because consumers that feel burned because they needed a vehicle during that time and they know they overpaid, they're not coming back to that same dealer. There's empirical data to support that. So the same thing here. Would you be willing to buy a dealership that's making $1 million or $2 million a year with a multiple of 3 or 4 or 5? Now that you know the FTC is essentially cracking down on the very same type of business that you're being asked to purchase. So that's why blue sky is important. Now look at it from your point of view as a potential seller, whether you're selling this year or 5 years from now. Your buyer is going to look at whether or not you're compliant. If you're a dealership that constantly gets cited, let's assume you didn't get put out of business, but the FTC cracked down on your practices and you had to pay a fine of $500,000, that's going to get in the trade press and it's going to get in the retail press. And now you have a black eye on your business so that when it comes time to sell your dealership, you have to worry that your buyer is going to say, well, you may have made $1 million, but you're also now viewed by the general public as unsavory and unreliable and lack of integrity. So you've actually diminished your blue sky value. So this goes beyond, how to advertise. I'm just trying to indicate to you that your inherent value of your business depends on the integrity that you display to consumers and to regulators. Now, the last 2 bullet points here, FTC and retail warranty reimbursement. Actually, FTC really should say F&I. It's a typo. Finance and insurance and retail warranty reimbursement. Those are 2 areas that I find that motorsports dealers don't pay a lot of attention to. Retail warranty reimbursement is a means by which you can get paid your customer pay rate for certain labor tasks that you do under warranty. Every motor vehicle dealer, every automobile dealer, I won't say every single one, but probably most, have already applied for a retail warranty parts and labor reimbursement. Powersports dealers have the same laws available to them in not all states, but in some states. So there's a way for you to recoup some revenue. If you feel that complying with these FTC requirements now are going to diminish your profitability, well, it's time to look at other avenues to enhance your profitability, and retail warranty reimbursement is one of those areas. F&I. Just this week, I noticed that there was a full-page ad in the automotive news, the Automobile Dealer's Bible, where a vendor took out a full-page ad talking about selling after-sale items after the customer takes delivery. Obviously, most dealers are programmed to try and sell things so that you can put them into the financing or the lease price, and then they abandon the notion after the customer takes delivery. This particular vendor, I won't name them because I haven't vetted anything yet, but it was interesting. I thought that these third-party F&I providers are trying to find ways to feather the nest of dealers, to open up the notion of going to consumers after they've taken delivery, presumably after they're happy with the product they bought, after they're out of the pressure cooker environment of being desked and turned over to an F&I person, or maybe they say, maybe I should have considered that item, the extended warranty or whatever else was presented to them. So the idea is it's opening up a whole new area of potential profitability, and that is selling F&I items after the sale to try and offset some of the potential losses of having to live up to the letter of the law here on the FTC requirements. I mentioned here direct-to-consumer sales only to point out that, and this is from my own personal experience, I don't expect anyone on this call to know about it, but in the automotive industry, my firm started recently, over the past 3 months, a class action against Volkswagen for a product called Scout, which is a wholly owned subsidiary of Volkswagen, where Scout is a manufacturer of trucks, a pickup truck and an SUV. And the plan is to sell direct to consumers and not go through the franchise dealer network. And we're trying to put a stop to that, claiming it violates the franchise laws. But putting that issue aside, the reason I included it on this slide is because when you ask these companies that are contemplating direct to consumer sales why they're entertaining that, they'll tell you because there are pain points in retail sales with motor vehicle dealers that makes consumers extraordinarily amenable to the direct to sale concept. There are consumers out there that view going to a dealer worse than going to a dentist for root canal. So Volkswagen has made this decision because they feel consumers are at their wits' end and don't like the dealer experience. So by complying with the law, it essentially guts the philosophy of companies like Volkswagen, because if suddenly consumers are no longer subjected to these, chicanery of these 6 different prohibitions, it's only logical to follow that consumers will suddenly become less agitated about the vehicle purchasing process. And that kind of negates the whole notion that direct-to-consumer sales is something of the future. It will no longer be necessary if that's the underlying pretext for manufacturers to try the direct-to-consumer sales methodology. All right, so what is the action plan that every dealer should implement? First of all, understand, reread the section 5, those 6 the 5 or 6 bullet points under the FTC Act. Very simple to understand, and we'll make them available to everyone. Establish a compliance department. The dealer principal has to be the quarterback in charge of that. Instead of having advertising agencies guide you, and there are plenty of great advertising agencies, you should have, if you're big enough, have an in-house attorney. If you're not big enough, then have an outside attorney whose sole focus is to guide you on what's compliant and what's not compliant in your advertising. That team should be the one that interfaces with your advertising agency, because advertising agencies are not lawyers. They may have access to lawyers, but the stakes are too high for you to say, I'll leave it to my general manager, or I'll leave it to someone on my advertising, my third-party advertising agency. Someone needs to put the good housekeeping stamp of approval. I'm not trying to sell anything, and I'm not the only law firm that does this, but I'll just explain. We have dozens and dozens of dealers that pay us a flat monthly fee just to look at their advertising. So it's not expensive, and we'll look at it and we'll make requested changes. So I'm not promoting our firm. There are plenty of firms that do this, but I've been doing this for 39 years. So I think we've perfected this. So integrate something like that. Don't assume that your general manager, not to say they don't understand this, but they're busy doing 100 other things. So the notion that they're going to look at every single ad, and keep in mind, it's not just advertisements, it's what your salespeople say on the phone to a consumer. If a salesperson misstates the price, and that is not a consumer, but that's an FTC shopper, well, you're going to have to pay the price. So there has to be levels of training, unlike anything that you've ever done before. There has to be weekly meetings. You have to explain programs to the sales team. Everybody involved in interfacing with consumers needs to be part of this process. And it has to be a written and approved workflow. Why is that important? It's important to avoid mistakes. But I can tell you, in defending dealerships in front of regulatory agencies, whether it's state, local, or federal, they'll spend a good period of time asking you what your protocols are at your dealership. Even before they get to the advertisement that they're complaining about, they want to know what procedures you have in place to guard against violations of advertising rules. Why is that important? Because a regulator has discretion to decide the type of fine that they want to impose, assuming you are in violation of one of these prohibitions or another. If they feel that something slipped through the cracks and that you've done your level best to avoid abuses to consumers, well, guess what? You might get cited, but they might not impose a $53,000 fine. It's within their discretion to say, you seem to have a good system in place based on the facts. This was one situation that was outside of the norm. You have an in-house attorney or you have an outside attorney. You have written policies and procedures. We see that you have meetings every month or every week, and you have everybody present sign these logs that they attended the meetings. So you're not a bad apple. And because you're not a bad apple, we're going to fine you $1,000 instead of $50,000. So you're not only doing this to avoid making mistakes, because you will make mistakes. It's impossible to have a high volume business and not have mistakes made. But you have to think defensively so that when that day comes that you're sitting in front of the Federal Trade Commission or the State Attorney General, you can present your dealership in a light that shows you're not the evildoer here. It's the dealer down the street. It's not me. I just made a mistake. And chances are you'll get a slap on the wrist, probably have to pay some penalty, but it won't be disruptive of your operation overall. Next point, vet the vendors. What that means is know about the advertising agency you're bringing in. Vet them carefully, make sure they're experienced, make sure they will submit to the protocols, that they'll subscribe to your written protocols and workflow, that they'll work together with your attorneys. Next point, one price. Dealers have asked me, does this mean I have to have a one price strategy? No, it doesn't. There's no correlation between advertising honestly and having a one price structure in your advertising. You can still negotiate. If your price says, $25,000 for this bike, and the customer comes in and wants to negotiate down to $24,000, it's your prerogative to accept or reject that offer. So we're not saying here that you have to have uniform pricing and you cannot depart from the pricing. You just can't go up. You certainly can come down. All right, OEMs and third-party platforms. Again, I mentioned earlier that the problem in the motorsports industry at the OEMs have list pricing that doesn't really reflect the true cost to the dealer. The FTC's position is whoever is responsible for the dishonest ad or the lack of transparency in your advertisement is the responsible party. So it may be the OEM. And to exculpate yourself from liability, what I'm suggesting here is that if your OEM is not falling in line and responding to this FTC enforcement actions, then you have to write them letters. The dealership should write the letter. Your legal counsel should write the letter. You should demand that they disclose transportation and setup fees and their cost to you. They should reimburse you, so you don't have to ask for the consumer to reimburse you. The point is, get them to come into conformity so that if you're called to the carpet by the FTC, you can say, listen, this is a problem that is created and persists outside of my dealership. It's at the OEM level. And these are the letters I've written to them. I can't force them to comply with the law, but I'm trying my best. Again, it takes a lot of the heat off your dealership. If you can demonstrate that you've done everything within your power to get your OEM or your third-party platform. I know that all of you use different platforms to post your inventory on your website. If that vendor is not transforming the way they do business in a manner that's consistent with Section 5, then you've got to get them to comply. Or you just totally take everything off your inventory immediately and then reinvent the methodology, whether it's with that company or another company, to make sure that everything on your website complies with Section 5. Have your attorneys write to these vendors. I can tell you that I did a little mystery shopping myself over the past few days on Powersport dealers' websites. It almost looks like none of your advertising partners are aware of what's going on. I can't tell you, I looked at about 20, I would say 17 still had the old way of advertising units for sale. So the time has come. What does rat on your friends mean? The FTC is encouraging dealers to call out neighboring dealers on bad practices. Now, rat on your friends was something we learned in law school. It said that if you find an attorney who's violating the code of ethics, it's your affirmative duty to report that attorney. And everybody said, but these are friends, these are colleagues, these are people I've known for years. If it's found that if you found a colleague violating the code of ethics and you didn't do something about it, you're essentially put in the same category of the unethical attorney. This is a very similar proposition. Now, I'm not saying that you should do this. I'm just alerting you to the point that the FTC is welcoming that the way to eradicate this problem, if you feel that your business is suffering because another dealer in your market area is not abiding by these rules, then you should be informing the FTC and they will take control of the problem from there. That's not their only source of data. They're relying on consumers, they're relying on state attorneys general, and they're relying on dealers to complain about other dealers. However, I'll caution you, don't rat on your friends unless your house is 100% clean, because an astute FTC compliance officer will say it's a means by which you're trying to camouflage your own misdeeds. So don't be caught ratting on somebody else if your house isn't clean, because it'll be turned against you. Create a paper trail for the FTC review. That just means more of what I said. Have a file. Everything you do from now on that relates to honest advertising should be documented, so that when the time comes, if necessary, you can say, I'm not a bad apple, I'm a good apple. However, this one just got away from me. Identify conflicts of interest. That potentially could be rogue managers who have a pay plan that is keyed to gross profit. You might want to retweak that and somehow factor in advertising violations, because you don't want your own team working against you because they have a different set of goals in mind. The FTC has announced that they will be sending out FAQs, frequently asked questions, to clarify some of these issues. They announced that about 30 days ago. Quite honestly, I would have thought by now we would have seen them. We haven't, so I suspect we'll see them in the next few days or next couple of weeks. I don't think they spent all this time and energy to abandon this initiative, so that'll help clarify what they're really zeroing in on. So be prepared for that. All right, so we're going to have a pop quiz, and I think we have a mechanism where you could actually answer these questions. We won't know who's answering them, so don't worry about getting a failing grade. But I think rather than have me explain the theory too much, the best way to approach this really is just, we're going to go through a series of ads. Hope I didn't block the ad so you can't see it, but this basically is a picture, an image of a bike for sale for $44,999, and the words factory rebates appear under it. So I'm going to ask you, if you can, I think you can now, vote whether this ad, based on your very preliminary understanding of Section 5, is compliant or not. So if you have it on your screen, I think we have it. I think we have this implemented. Yep, I can see that your votes are coming in. So it looks like 94% of you said no, it's not compliant. And I like that answer. And this is my thinking. The word factory rebates creates a lot of questions. Is that a rebate that was already applied to this price, or is that a rebate that will come off of this price? It's a little nebulous. And the whole point of Section 5 is that consumers can look at a prominent price and know exactly what they have to pay before they walk into your dealership. So the word factory rebates, I think, is being a little cute, because that could be interpreted two different ways. Okay, so you don't want to put in terms in your advertisement that creates more questions than it answers. And even though this is an example of something that your sales manager may have done in not a nefarious way, this could be purely innocent because there are factory rebates out there. And maybe your sales manager was being honest and was saying this $44,999 includes the factory rebate. So his intentions may have been excellent, but an FTC regulator looking at this may say, wait a second, they're trying to imply that the customer can pay less than $44,999 because there are rebates available. So that's why I think most of you, you answered this one correctly. So we'll clicking share results, and we can go to the next page. As long as I can get to it.
You just need to click on the PowerPoint once and then you'll be able to move it down.
PowerPoint. Click on PowerPoint. Okay.
And then just use your down. There you go.
All right. Here's example number 2. All right, let's take a vote on this. 17,499 says that's the maximum price. It says taxes and DMV fees are extra. All right, so can we get the voting screen up there? We'll see how you all feel about this. Is this compliant or does it present problems in your minds? Let's wait 5 more seconds and I'll give you the results of the poll. All right, so 73% of you said it's compliant and 29% said it's not. All right, so let's go through it. So it says maximum price. So keep in mind that the objective is to post a price that's prominent and transparent. It's an out-the-door price. The only thing that you can add on to this price are taxes and DMV fees. Now, 30% of you that said no, so that would make it compliant. 30% of you probably are wavering over the terms maximum price. The reason I think it's okay to say that is because it's consistent with the idea that the prominent price has to be the maximum price that the customer pays, except for taxes and fees. So I inserted the words maximum price to be a little tricky there, but I don't think it creates the same problem as the previous example where it allowed for 2 different interpretations. So we're going to treat this one as compliant, okay? So let's see if we can get to example 3.
You just click on your presentation once.
Okay, getting the hang of it. All right, so example 3, take a look. MSRP 22,949. How are you all feeling about that? All right, we'll wait 2 more seconds. All right, I wouldn't call this a trick question, but this one is a little close, right? Because if you're selling the unit at 22,949, you're okay. You can certainly sell a unit at MSRP. It's a little more problematic in this industry because we all know that selling at MSRP oftentimes produces a loss because your spread between cost and list is not that great, and you have to recoup your transportation and your setup fees. So you might be a little bit tainted by that. But I would err on the side of saying it's probably not okay. This is something that the FTC, keep in mind, you guys are experts. I would consider myself an expert because I've been doing it so long, not because I'm a retailer, but someone at the FTC might be troubled by this because they don't understand. So the insertion of MSRP in the ad might be drawing attention to you, and you're putting yourself on your heels in a defensive posture when you really never want to be in a defensive position. So this was a little bit of a trick question because if you are selling it at that price, you're okay. But you certainly don't want to draw the attention of a regulator. Okay, moving right along. Example 4. Take a look, a little more fine print here. So buy for $17,950 plus taxes plus tags. All right, we know taxes and tags are okay. What do you think of the bottom line? Less rebates you may qualify for. Active military rebate, first responder, recent college. I'm not saying these are typical in your industry, but I just wanted to illustrate the idea that, this price isn't exactly $17,950 if you qualify for some of these rebates. So can we put up the poll? Let me know what you think. Okay, looks like about 85% of you think it's compliant. You voted yes, and about 15% said no. And it's great that there's some disparity because it means people are thinking. Because when I see fine print, I worry that it's altering the message above it. in a meaningful way that could potentially be deceptive. However, you certainly couldn't put these rebates in the price because not everybody qualifies for them. So you have to be really transparent in letting the consumers that do not qualify for military or recent college grad or first responder know that they're paying $17,988, whatever that price was. So the actual answer is yes, this is compliant because there's no room for doubt, even though there's a lot going on, as long as the average, and keep in mind, the standard is the reasonable-minded consumer, not the complete idiot or someone who graduated second grade, but the reasonable consumer. The reasonable consumer knows if they are an active military person or if they're a first responder or if they just graduated college. So there's really no room for confusion here. So this ad would comport with Section 5 of the FTC. I wanted to include ads like this to kind of show you real world, because I think that's ultimately where you're going to go with your ad. You have to figure out whether the language you put in your ads are going to pass muster. All right.
That disclaimer could be worded. That disclaimer could have been worded a little bit better, though.
Yeah, it's a little dicey. You may qualify for, but it leaves the consumer in a position of having to decide for themselves. Now, you could say, what's a recent college grad? What if a consumer graduated 3 years ago? So yeah, we can get in the weeds on that, but on the whole, it's okay. All right, here's another example. You got your prominent price, and then a disclaimer. And by the way, I've seen this quite a bit on a lot of your websites, this language. Due to supplier issues, pricing and freight are subject to change without notice. Can we get the poll, the voting? What are your thoughts on this one? Okay, looks like unanimous. All right, we're getting a couple of naysayers. We got 96 and 4. 96% say no, no good. 4% say yes. All right, so the disclaimer, why is it a problem? Because you're basically saying the price can change by the time you get into the showroom. And presumably that gives the dealer the protection. The better practice is that there should be an expiration date on the ad, because a consumer should never be made to feel that language like this is there to set them up for disappointment. Because if it can be changed without notice, a doubtful consumer is going to say, well, I have to race over there and I don't have time to shop then because this could expire in 10 minutes. So it doesn't give me, as a consumer, the ability to shop intelligently on the internet or elsewhere in a reasonable, comfortable environment where they're not being pressured to come in and buy this particular unit. So again, this falls within the realm of something that would raise the ire of the FTC, because it's designed to create urgency where urgency should not exist. A dealer generally knows when a rebate or a program or an incentive is going to expire. Not always, but the burden should be on the dealer to put in an expiration date and not make the consumer think that they better rush and not comparison shop. Okay, let's go to number 6. All right, take a look at that ad. All right, let's do some voting. You got 2 prices on this ad. Keep that in mind. You got the $17,950, and then you got the $18,950. Okay. Wow, this is interesting.
I think
the votes are actually at 50-50. It's actually 50-50. Again, this might have been a little tricky on my part because it requires that you remember something I said at the very beginning, and that is you have to live or die by the prominent price in the ad. The prominent price in this ad is $17,950. The selling price is $18,950. So if you don't sell that unit for $17,950, you violated regardless of whether you sold it, you committed a violation because the prominent price in the ad is not the buy price. So on its face, the ad is a violation. Even if you ultimately sold it for $18,950, as you indicated, that's the selling price. The fact is the consumer is not held to that high standard where they should have to look beyond the prominent price that's displayed. So I expected that would be a close call, but this was split right down the middle. So there's a lot of work that has to be done here to understand, and that's why your advertising people might miss that. So there's a lot of vigilance and a lot of preparation to make sure you're setting your website up so it's not drawing unnecessary attention. Okay, I think we have one more. Let's see. Whoops. All right. This one has no price, competitive pricing, family owned and operated for 30 years. What are your feelings on this one? Okay. Looks like it's split, but I'd say it looks so right now I'm looking at 65% say yes and 35% say no. All right, so it's mixed. All right, so footnote to this example. Some states, as you may know, require that you have pricing in your advertisements, not all states. So assuming you're not in a state that requires, I'm going to explain something further because I said earlier, well, what about state and federal? Federal prevails. But there's nothing in the federal law that says that you have to advertise a price on every unit that you display. So there's no conflict. So if your state says you must list a price, there's no conflict between federal and state. So in that case, I would go by what your state mandates. But most states don't require you to put a price in your advertising. In those states, you can just display a picture of the product and espouse its virtues, great off-road vehicle, fast, comfortable, whatever. Here, you're just saying competitive pricing, no prices listed. And there's nothing wrong, obviously, with saying family owned and operated for 30 years. So what you're doing is you're selling a value proposition of your dealership, which is one of the things I talked about earlier. Turn the page on these pricing games and start talking about the value of doing business at your dealership. And that's why this one is designed to talk about 30 years family owned and operated. Is it untruthful to say your pricing is competitive? Presumably every dealer's prices are competitive. Otherwise they would never sell anything. It doesn't mean you're talking about rebates. You're not talking about sales deadlines. It just means that you compete with the rest of the dealers in your market area. Nothing disingenuous or deceptive about that. So that's why this ad would be deemed compliant. I just wanted to give you a flavor. I mean, we can go on and on and on. I'll probably give you 50 different ads and we would have a split vote. But I think the exercise illustrates that this is not cut and dry and black and white. So there's going to be a learning curve, not only at your level, you're the experts, but at your advertising agents or agencies level with the OEM and what they can do and can't do. So there's nothing set in stone here. And that's why you need to have a team and you need to have protocols and you need to have an attorney involved that's familiar with advertising regulations. Okay, so with that, I know I probably, Mark, went a little overboard on the time, but I would invite whatever questions have come in.
So,
And
Mr. Bellavia, I believe that almost everybody who participated in the webinar submitted a question. I think if we stayed on for another 6 hours, it would probably be almost impossible to get to all of these. I am going to summarize all of these and send them over to you. I do have a couple we're gonna hit on real quick, but I will summarize all these and get them over to you if I could get some responses to those, and then we can share them with everybody. Would that be all
sure.
right with you?
Yeah, and also there's my email address. So if anyone has a question that doesn't get, read today, just shoot me an email and I'll get an answer to you.
So a couple of things. One of the reasons I wore the BMW sweater today or hoodie is that BMW today in the Powersports business is the only manufacturer that is complying with this. So their freight charge is included in their MSRP, and they reimburse the dealer for the setup through the warranty system. The NPDA, we polled 150 dealers earlier this year. About 90% of dealers are in favor of the manufacturers including freight and setup above the line, so including that in the MSRP. That is the primary focus of the NPDA, is to get all the manufacturers to comply with that for the 2027 model year, so coming up pretty quickly. We've gotten quite a bit of pushback so far, but it's not something that we're going to let up on. Would there be, you had talked about, creating this paper trail and reaching out to the manufacturers and saying, hey, this is something we want to do. And a lot of times in the industry, when somebody wants us to do something, they create a system where it's easy for dealers to generate letters and send them to different legislators or different individuals. Would you be willing to maybe create some letters that we can share with our dealers, that we can uh, get a campaign going for everybody to actually submit something to the manufacturers saying, hey, this is what dealers really want. This is what we really need.
Yeah, this is something we've done quite a bit in different scenarios. So that's an excellent idea, and we'll do that. And I think, to the extent you educate me on, the disparity and what your goals are with different manufacturers, and we can tailor the letters accordingly. I remember about a year ago when certain states, I mean, this is not related to power sports necessarily, but laws were passed that obligated manufacturers to pay reasonable um, labor time charges for warranty work. And the statutes actually said the dealer has to declare what third-party publication it uses to establish time guides, like Mitchell and some other ones. So we actually prepared letters for each manufacturer based on the passage of that law, and we disseminated it through the various state dealer associations. So this is exactly what you're asking for, and I think it makes great sense. So I'd be happy to put together letters once I get a full understanding of your goals, and then you can distribute them to your members, and then they can put them on their own letterhead. And
That
then
would be
it would be
great.
very difficult then if a problem arose relating to the Federal Trade Commission, where the manufacturer pretty much is the cause of the problem, then every dealer can say, listen, and the association can say, we've tried for months and months to get them to respect the new regulation requiring uniformity in pricing, and they've made it such that we couldn't comply, or even though the dealers are complying, there's still confusion in the marketplace because dealers are going on the manufacturer websites and seeing MSRPs that are lower than the prices we're selling the vehicles for. So it puts a blemish on our reputation as retailers, as though we're gouging consumers. And then they wind up going to a different brand or a different dealer, not knowing who's to blame. So I
Yeah,
think that's an excellent idea.
I think that would be a great help. And we have been working with Lead Venture and Dealer Spike to update their vehicle display pages to incorporate some of these new ways of marketing the vehicles. So not quite there yet, but have been working with the leading website provider in the industry to get that happen. Um, there is in the industry, there's a lot of situations where the manufacturers will present to us that we can either take a rebate on a vehicle or the consumer can take low rate financing. You're suggesting if you've got a vehicle that's retails for $20,000, it's got $1,000 rebate on it, can a dealer advertise that vehicle for $19,000 and say excludes promotional financing, or you think that's a problem area?
The general rule is if the price that you're going to advertise is available to every consumer, then you can say that. And what I would do there is to say to the consumer, there's a rebate of $1,000 you can take advantage of it. Certainly, you can introduce the option later on. The consumer comes in to say, well, if you want to finance, or you can do it the other way. Talk about both options and leave it to the consumer to decide. As long as there's no room for anyone to say that there's some um, lack of sincerity or deception or potential confusion, and it's available to everyone. So in the example you just gave me, if every individual could either opt for $1,000 rebate or discounted financing, are those the two options?
Yes, sir.
Yeah. Then as long as they're fully disclosed, there's nothing disingenuous, as long as it's available to every potential consumer that comes in. Now, if you say to me, the rate is only available if someone has an 800 credit score, that's where it's going to get murky. But if, objectively speaking, option A or option B is available to everyone without qualification, then you're in a safe harbor.
The we do have some situations where the manufacturers come out with vehicles that are available for pre-order only. Honda, Suzuki, Yamaha have all done it. Kawasaki does it every year with the H2. And dealers want to advertise those vehicles knowing that it might be 60 or 90 days until they come in. And the only way that we are going to be able to get that vehicle is by placing a pre-order for it. Are we best, if we want to advertise those vehicles with a long lead time, that we advertise them without a price, or are we still going to get in trouble if we advertise those vehicles?
I don't see a problem indicating that there's going to be a long lead time. These are, factory order vehicles only, and average expected, delivery time is, 4 months or whatever the case may be. There is a problem if the pricing that you're going to quote is not going to hold for those 4 months. So I would stay away from putting a price in that might fluctuate based on whatever happens in the ensuing 3 or 4 months. So, like I said, you're not obligated to put a price in except for those few states that have that requirement. And this might be, if it's a high demand item, dealers have to consider whether they need to put price. It's reflexive. I understand, you always want to put a price in an ad, but it's not always necessary. And the question is, if you don't put price in, are you wasting dollars on that ad? I don't know the answer to that. That's something that your membership would have to, but if you are going to put a price in, maybe you want to put MSRP. If you know MSRP, ultimately you're going to have to honor that price. So a business call has to be made as to whether you're better off putting in a price and hoping it holds and maybe sustaining a loss or a reduced margin, versus not putting any price in or putting a higher price in that leaves you room. And then the question is, do I remain competitive if I put a price in that's, $500 over MSRP or $1,000 over? Am I no longer competitive because my other competing dealers are putting in a lower price and they're rolling the dice that the price stays firm? So there's no right answer to that, but I think ultimately the answer is don't put anything in the ad that might change the price based on factors outside of your control.
Yeah, couple more questions and then we will call it a day and I'll send everything else over to you. Does this law apply to both new and used inventory? We have some dealers that charge a reconditioning fee on used inventory. And so should that used inventory be advertised with that recon fee built in?
Yes, it applies to new and used. So whatever it is that you're putting in the price, again, like I said earlier, you don't even have to put in reconditioning fee. If the reconditioning fee brings a unit from 19,000 to 20,000, just advertise the unit for 20,000. If you want to reference the reconditioning fee, you can. There's no law against it, but it almost becomes irrelevant since everything has to be in the out the door price anyway.
Yeah. You had mentioned the scenario where dealers or in real estate where property wasn't coming off the website. What about if a dealer has sold a vehicle and it's clearly marked as sold on their website? Is that still okay or?
Well, you wouldn't put a price on that unit, right? Because it's already sold. If the thought is to bring people in so they can order a similar vehicle from the factory, I don't know if that is common. What would be the purpose of putting that on the website unless it's to try and sell a similar vehicle? So I would be careful. You can certainly do it. You wouldn't be. You'd have to make clear that that specific vehicle is sold. However, others will become available for order. Whatever the truth is, I would, and you'd have to craft the ad in a manner that doesn't create any ambiguity or any questions. So as long as it's truthful and it doesn't violate, the reasonable consumer doesn't think it's still in your premises and it's for sale and it's available, then it should be okay. There's nothing illegal about taking orders for future vehicles at a predetermined price as long as it's disclosed. The problem only arises when the inference is drawn that the vehicle is at the dealership facility.
I can tell you that the dealer who got the $75 million fine and the $3.2 million, I think they're having to pay back $75 million to consumers and they got fined $3.2 million. They're right around the corner from me. And when you go over there, there's not a smile in that entire dealership. So there is nobody over there that looks happy today.
Well, maybe the salespeople and the managers got hit with some of those fines. That may be the reason.
Yeah, it's a pretty bad situation. Well, Mr. Bellavia, we ran 30 minutes longer than we thought we were going to, but I really appreciate you taking the time out of your day to take dealers through this. It's definitely been one of the most common questions that I've gotten over the last few weeks. We are still working on this on a lot of different angles to keep dealers informed and to hopefully get the manufacturers over the hurdle of including those additional costs above the line so that we can really simplify the process for everybody. We know that not every dealer is going to be happy with that, but the vast majority have asked us to focus on that. So that is what we're putting our energy towards. If you are a member of the NPDA, we really appreciate your support. You know, these programs like we've done here with Mr. Bellavia and his team, these are some of the benefits we try to bring to our members. If you are not a member of the NPDA, please consider joining. It's $395 a year. It's a small price to pay. You'll continue to be involved in webinars like this. Got another webinar tomorrow, and then we're doing webinars almost every week through the rest of the summer. So quite a few more planned that are open and available that cover all aspects of running dealerships. So with that, I will call it to an end. We will put this recording out on YouTube so that you can reference back to it. If you want to share it with any of your team members, that will be available as well. And I will also get the list of questions sent over to Leonard and his team. And as soon as we get those answers, I'll get with our marketing team at the NPDA, and we will put together a newsletter where we send those questions out along with the answers. So with that, I will call it an end to the day. Thanks again for your participation this afternoon, and I hope that everyone has a good afternoon.
Thank
Bye.
you all.